Hi, welcome to our Remedial Law Review version 2.1. This is version 2, meaning the coverage, the topics under this video are different from version 1. And point 1 means that this is the first ever recording regarding these sets of topics. Just a reminder, this video is not intended for legal advice. If you have legal concerns, please contact a lawyer. So let's start. So we start with a question that was asked in bars 2019, 2018, and 2016. And this is in relation to the rules in environmental cases. So the question is, define or distinguish the writ of Kalikasan and writ of continuing mandamus. Explain the advantages derived from a petition of a writ of Kalikasan before the Supreme Court over a complaint for damages before the RTC. So we will answer these questions by exploring and understanding the Writ of Kalikasan deeper. So what is a Writ of Kalikasan? It is a remedy available to a natural or juridical person or organization on behalf of persons whose constitutional right to a balanced and healthful ecology is violated. So I'd like to pause and emphasize the words on behalf of persons, because this is what's unique with the Writ of Kalikasan. And then it correlates to the constitutional right to a balanced and healthful ecology. Here you remember what case is this? Okay. Or threatened by an unlawful act or omission of a public official, private individual, okay, emphasize again, private individual, not just an act, not just mandamus, but it includes private individuals. Okay, so as compared to mandamus, which only covers public officials who are performing their official duties, okay, that are not discretionary. So another qualifier here is that would prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. So emphasis is in 2 or more cities or provinces, and this talks about the magnitude of the potential damage. So here we see the legal standing, and then we can see here the potential defendant, and we can see here the potential threat or damage that could arise from the act of such defendant. So before we proceed, I'd like to share this verse that reminds us why we should keep our surroundings free from pollution and why should we protect the environment. I'd like to share this verse from Deuteronomy 23:14. It says here that, "For the Lord your God walks in the midst of thy camp, to deliver you and to give up thine enemies before thee. Therefore shall thy camp be holy, that he see no unclean thing in thee, and turn away from thee." This talks about not just spiritual uncleanliness, but also physical uncleanliness, because the rationale here is that God himself is walking in their midst, therefore they should keep cleanliness. That's why we have a saying that cleanliness is next to godliness. That's why it's also very important on a spiritual perspective to care for our environment and guard our environment from pollutants and from destruction caused by uncleanliness from our human-made activities. So that's the verse. So in other words, we have a backup, not just from the law, the rationale, the public policy, but we can see from a very strong backup and support from a spiritual perspective, from God himself, that he is a God who wants cleanliness. So going further, what is a writ of continuing mandamus? A writ of continuing mandamus is issued by a court in an environmental case directing any agency or instrumentality of the government or officer to perform a series of acts decreed by final judgment. So kanina, it can be directed to private entities, but the writ of continuing mandamus or mandamus is directed to any agency or instrumentality of the government or officer thereof. So in other words, ministerial functions, okay, those that have to perform what they are obliged to perform. So that's a continuing mandamus, to perform a series of acts decreed by final judgment, and it shall remain effective until the judgment is fully satisfied. So from the word itself, continuing, until it is fully satisfied. So that's the essence of continuing mandamus. And then again, it directs only agencies or instrumentality of the government and not private persons. Okay, we see here again splitting the phrases. So the nature, it is a writ, and then the obligor is the government, and then the obligation is to perform a series of acts decreed by final judgment until, so this is the duration, until fully satisfied. So here's a chart of the comparison and distinction between a writ of continuing mandamus or writ of kalikasan. Okay, so please remember that these highlights have been asked in the bar exams. So for continuing mandamus, the purpose is to require the performance of ministerial duty as mandated by law, and that includes, the law includes a special law or a charter. This was asked in bar 2016. Okay, so if there's a charter, city charter, that for example protects or obliges a certain official to carry out an act to protect the environment, then you have to resort to continuing mandamus in that regard. However, writ of kalikasan is a legal remedy to prevent an environmental damage that is wide scale in magnitude, and it can be directed towards private or public officials. Okay, now we go to the advantage of writ of kalikasan, and this was asked in the bar exam. Okay, or the while ago, the bar exam that we have read, the bar question that we have read rather. So here, writ of kalikasan is a citizen suit, meaning, what does it mean? Citizen suit can be filed by any person, okay, any person, okay, any public interest group. So remember, either one person, one company, or a group, okay, on behalf of persons whose right to what? To a balanced and healthful ecology, okay, is violated. Okay, locus standi is relaxed. So this is the advantage of writ of kalikasan. However, in continuing mandamus, it can only be filed by a person aggrieved in such act of the government official. Okay. However, in the action for damages, furthermore, it can only be filed by the real party in interest, okay, or the person who is injured or has interest in the case. Where to file? In the writ of kalikasan, it can be directly filed with the Supreme Court or any stations of the Court of Appeals. While continuing mandamus, RTC, exercising jurisdiction over the territory where the actionable neglect or omission occurred, or with the Court of Appeals or the Supreme Court. So it can also be filed with the higher courts. However, another distinction of writ of kalikasan is that this is wide scale. Okay, this is wide scale, affecting or prejudices two or more cities or provinces, and that's why any person on behalf of other persons whose right is violated can file directly with the Supreme Court, and then this has no docket fees. And compare to an action for damages, it has docket fees. Okay, and then it may be filed separately. Action for damages may be filed separately from the writ of kalikasan. This is as provided for under the rules on environmental cases, or Rule 7. So we can find it here that besides filing a writ of kalikasan, you can file a separate action for damages. Okay, so these are the main difference. And where to file? An action for damages is of course filed with the RTC, while the writ of kalikasan can either be filed with the Supreme Court or any stations of the Court of Appeals. So that's the hallmark. These are the hallmark differences between the two. So let's look at writ of kalikasan closer, and we can find that in Rule 7 of the rules in environmental cases. So there are 5 important sections that we need to take note, and some of these have already been asked in the previous bar exams, particularly bar 2016 and 2018. So let's go to the nature of the writ of kalikasan. Let's remember that it can be filed on behalf of persons. In other words, the legal standing is relaxed, or the locus standi is relaxed. And then as long as there is a violation of the people's right to a healthful ecology or balanced ecology, inhabiting two or more cities or in provinces. So that's the magnitude, that's wide scale. As to the contents of the petition, remember that it must include the circumstances of the petitioner and respondent in order to prove the qualifications above. Okay, so they must be inhabitants of two or more cities. I remember the case of Labo-Galbalaan. If I'm not mistaken, it had included the Writ of Kalikasan, and then we also have the petitioner, of course, because it has to be filed by what? By a private entity or a juridical person, a natural person, or what? A group of persons, such as NGOs registered under the agency of a government. And then the acts complained of, again, to qualify the wide-scale qualifier, relevant and material evidence, of course, as a requirement to support your allegations, and then certification that there's no similar action filed in other courts, in other words, non-forum shopping, reliefs prayed for, including TEPO or Temporary Environmental Protection Order. So another feature of the contents is that there is no docket fees. Okay. Next is the issuance of the writ. The Supreme Court or any station of the Court of Appeals within 3 days from the filing of petition may file a writ or a TEPO, Temporary Environmental Protection Order. And then respondent must file a verified return within 10 days. All defenses not raised in the return shall be deemed waived. So it's like the omnibus rule, right? And then, omnibus motion rule, sorry. And then not a personal service is equal to substituted service, which we will discuss later. Since it has been mentioned, we will be discussing substituted service under the rules. And then if there is a general denial, that would mean admission. So there must be specific denial. And then the prohibited motions include motion to dismiss, extension to file return, postponement, counterclaim, cross-claim, reply, motion to declare respondent in default. So this could be dilatory in nature, so these are prohibited motions. And then court has contempt powers over a respondent who refuses or unduly delays the filing of return. So we will also discuss later the contempt powers or the rules on contempt under the rules of court. And then failure to file return, the court will hear the petition ex parte or on its own initiative. And then next we go to the hearing. There must be a preliminary conference to simplify the issues. This sounds like a pre-trial. Hearing shall not extend beyond 60 days to expedite and to achieve swift justice. And a party may file to avail the following reliefs. First is ocular inspection, entry with permission from the proper people or persons, photograph inspection. And then documentary inspection or production. Motion must establish the magnitude of the violation or threat that is calculated to prejudice the life, health, and property of inhabitants in two or more cities or provinces. And court has contempt powers over a respondent who disobeys a lawful process or order of the court. So the two main ones are ocular inspection and documentary inspection. Last, we go to the submission and judgment. Court submits case for decision, and court may require the filing of memoranda. And then the judgment is made within 60 days from the submission of decision granting or denying the writ of Kalikasan. Reliefs that may be granted under the writ includes respondent to permanently cease or desist acts in violation of environmental laws, directing a public or private entity to protect or rehabilitate the environment. Okay, so that's the one is negative, the second one is positive, such as to monitor, to make periodic reports, and then this one is accountability. So negative, positive, and accountability, reporting, compliance, and then other reliefs relating to the right of persons to healthful and balanced ecology. Please remember that in the contents of the petition with the Supreme Court or with any stations of the Court of Appeals, again, this is filed with the Supreme Court or the court or any station of the Court of Appeals. That's why this is more beneficial rather than filing an action for damages. And then, besides filing it with the Supreme Court, the petitioner may also file a separate civil, administrative, or criminal action against the respondent. And then, the remedy for the judgment is appeal to Supreme Court under Rule 45, appeal within 15 days from the date of notice of the adverse judgment or denial of the motion for reconsideration, appeal to Supreme Court under Rule 45, and then appeal may raise question of fact. Okay, so the Writ of Kalikasan mentioned that if personal service is not available, then we have to resort to substituted service. So let's go to substituted service. What is substituted service? It is a method of serving court documents when personal service of summons is not feasible. What rule governs it? It's Rule 14, or the rules on summons. What is the preferred mode of service of summons? So primarily or generally, the preferred service of summons, since this is the acquisition of the court's jurisdiction over the person of the defendant, then it must be served personally. Okay, since this is also an action in personam. The preferred mode of service is personal service. So what is personal service? That is by handing the physical copy of the summons to the person of the defendant. Bar 2017 and 2013 question: when can substituted service be resorted to, and what are the requirements for a valid substituted service of summons? So, these are the answers. Substituted service cannot be simply invoked or resorted to by the sheriff or the server. Okay, in cases Bar 2017, the defendant's wife merely invoked that her husband, defendant, went out of town. So that's not a valid ground to resort to substituted service. Also in Bar 2013 and 2006, only the secretary was present. So there's no hiding here, but the defendant was not present. Only the secretary, okay, at the first visit of the sheriff. So these are not grounds to resort to substituted service. For substituted service to be available, there must be at least 3 attempts in 2 different dates, Section 6, by the sheriff or the server to personally serve the summons to the defendant. Okay, before the 2019 amendment, this was called as the earnest efforts to serve the summons personally to the defendant. And because of the amendment, this has been codified. So again, it's at least 3 attempts in 2 different dates. So for example, let's say Monday morning and Monday afternoon, and then Wednesday afternoon. So then if the defendant is still unable to be served with personally with the summons, then the substituted service can now be resorted to. This is also called the 3 attempts rule. So without this 3 attempts rule, the service of summons is void, or the substituted service is invalid. So how shall substituted service be effected? So once it is satisfied that there has been serious attempts to deliver the summons personally, and that means at least 3 attempts in 2 different dates, then these 4 actions can be resorted to. So by leaving summons, so I made icons here so that we can easily remember. So house, corporation, security, or officer, and then email. So by leaving the copy of the summons with a person of at least 18 years of age at the residence of the defendant. Okay, so I did not read, I just looked at the picture, but I think I got it, the keywords, I've got them. Okay, sufficient discretion. So we can put here like a brain here with sufficient discretion, and then at the defendant's office or place of business with a competent person. So I place stars to symbolize competency. And then with the officer of or the chief security officer or any officer of the condominium corporation or homeowners association where the defendant resides. Okay, if the server has been refused entry. So remember that this number 3 can only be resorted to if the server has been refused entry. Okay, and this has been asked in bar 2022 that it was left with the hotel security or chief security officer of the hotel, and therefore since it is not the residence of the defendant, then the substituted service was not validly effected. Okay, so this was bar 2022, and by sending an email to the defendant's email address if allowed by the court. So again, if allowed only by the court, emails. So if the substituted service has been effected, what should the return state? So the return is merely the report made by whom? By the server or the sheriff. So first, it must show that there's an impossibility of prompt personal service, and when we say prompt, that it cannot be done within 30 days. And within that time frame, there must be a showing or details of the at least three attempts made in two different dates. So those dates must be recorded, the date, the time, and the personal circumstances or the details to locate the defendant residing thereat. So first, it must be 30 calendar days from issue and receipt of summons. So let's say I am the sheriff. So the return will state I have received the summons against B on June 5, 2024, and until let's say July 5, 2024, I have made 3 attempts on these dates on June 10, June 15, and I have made 3 attempts at June 10, 10 a.m., June 15, 2 p.m., and June 15, 5 or 4:30 p.m. And I have made these attempts in the residence of the defendant, which is let's say 123 Lacson Street. So the name of the proper receiving person, therefore I have the resorted to the substituted service of summons, and seeing that C is present at the house of B at the and B this is not the official but in my understanding, so I will say that C is 24 years old, and he is the mother of B, and of sufficient discretion has received a copy of the summons in B's residence. Okay, so if that is if the case is letter A, if it's served in the residence. So if it's in the business or office, then a competent person in charge of the business, that could be a secretary. And if not allowed entry, then it can be served upon the security officer, chief security officer, or the officer of the condominium corporation or homeowners association, if the case may be, or in case of a homeowners or subdivision. So that's what the return should state. So let's now go to summons. So kanina substituted service. Now let's go deeper into the details of summons according to Rule 4. So let's have a deeper look on summons. Who issues summons? Section 1 states that it is the clerk of court under the court's direction that issues summons. When are summons issued? When the complaint is not dismissible on its face under Rule 9, and then within 5 calendar days from the receipt of the initiatory pleading and proof of payment of requisite legal fees. So if it's not dismissible under Rule 9, that also could be like, for example, the court has no jurisdiction, etc. And within 5 calendar days from the receipt of initiatory pleading and requisite legal fees. Again, legal fees are have jurisdictional value. Okay, the payment of legal fees entails the acquisition of jurisdiction by the court. Okay, what is Rule 9, Section 1? Dismissible on its face. So, a while ago we stated we encountered that, and it means that when it appears from the pleadings or evidence on record that the court has no jurisdiction over the subject matter. So, yun sinabi natin kanina, the court has no jurisdiction. And just to review again, BP 129 as amended by RA 11576. So, for example, If the claim is 3 million and it was filed with the MTC, then the court has no jurisdiction and it may dismiss the case. There is an action pending between the parties for the same cause. So this is litis pendentia, right? The action is barred by prior judgment. Again, this is res judicata. And by statute of limitations, or also called as prescription. Okay. What are the contents of the summon, of a summon? So they are directed to the defendant, signed by the clerk of court, under seal, and contain, number 1, the name of the court and parties to the action. Let's say People of the Philippines versus Juan de la Cruz. Letter B, authorization for the plaintiff to serve the summons to the defendant if authorized by the court upon ex parte motion. So the plaintiff himself can file an ex parte motion without the defendant's consent, or without the parties, without the defendant's part or initiative. Upon the petitioner's own initiative, he can file that the court will serve summons, or that the plaintiff himself will serve summons to the defendant personally. And then letter C, a direction that the defendant answer within the time fixed by the rules. And letter D, a notice that upon failure to answer, the plaintiff will take judgment by default and be granted relief applied for. Okay, so judgment by default, in other words, that can also mean presentation of evidence ex parte. Okay, and then the court will rule upon the evidence presented by the plaintiff only, without the defendant. So that's a part of due process, to notify, to warn the defendant that if he will not appear, or he will not surrender, okay, then, or he will not voluntarily appear before the court, again, that means that the other party can present evidence against him. So if the defendant is a minor or incompetent, what shall be the attached to the original summon and each copy thereof? So ano yung dapat i-attach pag minor? A copy of the complaint and order for appointment of guardian ad litem. Okay, so there must be a guardian, or the parent, of course. Who serves summons? Section 3. So that is the sheriff, his or her deputy, or we call server, or other court officer. Or number 4, the court may authorize the plaintiff to serve the summons together with the sheriff in case of the failure of the aforementioned. So again, it can be here, okay, authorization to the plaintiff. When may the court authorize the plaintiff to serve the summon? In cases where it will be served outside the judicial region of the court where the case is pending. So if malayo, if hindi na abot sa scope ng court, then the plaintiff may serve the summons. So what if the plaintiff is a juridical entity? The juridical entity shall attach a board resolution or secretary certificate notifying the court in writing or of its authorized representative. It shall state that the representative is duly authorized to serve the summons on behalf of the plaintiff. So let's go to summons on private entities and spouses. What if the defendant is a foreign private entity? So let's remember foreign private, not public. Because if it's public, then it's no longer under civil procedure, but that could be under public international law. So, and if no resident agent in the Philippines, so always remember, if it's private entity and it's foreign, there must be a resident agent. In other words, there must be a representative of that foreign private corporation inside our country. But if there's none, nor is it registered in the Philippines, service may be effected outside the Philippines through the following means. So kung walang representative dito sa ating bansa, then the summons should be served outside. And these are the following methods. First, personal service with the assistance of a foreign court and Department of Foreign Affairs. So still, the preference is still with personal service. But at this point in time, since it is outside our jurisdiction, then we must ask for assistance of a foreign judiciary and of course the executive, which is the Department of Foreign Affairs. And then one-time newspaper publication in the foreign country and by registered mail to defendant's last known address. So pag ito yung pinili, publication, it must be coupled with the registered mail. And then facsimile or fax, and then electronic means with the prescribed proof of service, and by such other means as the court may direct in its discretion. So dito, this is a tricky, or this could be nuanced because it can be chosen by the court to send the summons via Viber, for example, or other messaging apps that are popular right now, if allowed or if given permission by the court. F, through methods consistent with established international conventions to which the Philippines is a party. Section 9. If with resident agent to himself. So default, so pag may resident agent, punta ka talaga always sa resident agent. If no agent with a government official designated by law, sorry, or with any of its board of directors or trustees within the Philippines. So ito rin yung mga options. Pag walang agent, either you resort to these personal service abroad or you resort to serving it with the designated official assigned by law. Next, what if the defendant is insane or a minor? So, service shall be made to his parent if minor or legal guardian. That could be like a legally appointed guardian or the hierarchy of guardianship as provided for by law. If he has none, then guardian ad litem, which shall be applied for by the plaintiff. So plaintiff pa rin yung mag-initiate that a guardian ad litem will be appointed. How about if spouses are sued jointly? Then summons should be made to each spouse individually. So again, jointly, individually. So yung di ba pag sa oblicon, if joint obligation, it can be pursued to either one of them and then each to his own. So each one mananagot sa kanyang obligation. Pero pag solidarily, then one of the parties can be liable for the whole obligation, and that party has the right to pursue the other defendants. But in this case, in the service of summons, it should be made to each spouse individually. Okay, let's continue on the service of summons on juridical entity. What if, so kanina, private, foreign. Ngayon naman, private, domestic. So pag domestic, let's say a corporation under the Philippine Stock Exchange, service of summons may be found on the following, or with their may be served on the following, or with the secretaries wherever they may be found. So it should be, or it could be served to the president, to the corporate secretary, and to the treasurer. So ito yung top 3. Diba? It's required by law, president, secretary, and treasurer. If wala sila, then the manager, managing partner, pag partnership, so again, managing partner yung in charge sa operations, and then in-house counsel, if there's one in that juridical entity, upon the person who customarily reserves the correspondence at the principal office. So if wala yung anim na ito sa taas, then yung person na traditionally or usually nagre-receive ng mga correspondence. And if it's under receivership or liquidation, then under to the liquidator or to the receiver. Bar 2011 question. What if the juridical entity has no personality, or the entity has no juridical personality? How may the summons be served? So paano yan? Pag hindi siya, for example, registered under SEC, or nagpapanggap-panggap lang sila na asosasyon or korporasyon pero wala pala silang juridical entity. So kanino ibibigay, i-serve yung summons? So the answer is, summons may be effected upon all defendants by serving upon any of them. So let's say nagpapanggap silang board of directors or board of trustees or incorporators or partners. So the service of summons may be effected to either one of them to take effect and to acquire jurisdiction to all of them. So parang estoppel pa rin, no? Corporation by estoppel. Or upon the person in charge of the office or place of business or that customarily receives correspondences in the name of the entity without juridical personality. So tandaan, either sa mga incorporators, alleged incorporators or alleged partners, or sa person na customarily nagre-receive. For example, office manager. Okay? So we have to kumbaga default or estoppel pa rin sila, stop pa rin sila dahil they are acting and the people are relying on such belief that they are a juridical entity. Bar 2011 still. So sino naman yung hindi bound sa summons na yan? Yung mga nag-sever ng kanilang mga relationship sa entity na yan before the action was filed. So isever mo na ang relasyon mo sa mga hindi totoo. Pag hindi totoo, pag nalaman mo na hindi totoo, tumakbo ka na dahil masasaktan maano ka lang. Pag nahuli yan at nandyan ka pa, alam mo nang mali, alam mo nang hindi tama, alam mo nang peke. Hugot, no? Umalis ka na, mag-sever ka na. Okay? So nilalagyan ko ng hugot para mas matanda natin. So hindi ka bound individually pag alam mo na peke sila o illegitimate sila na korporasyon, umalis ka na. Kasi pag umalis ka at sinervan sila ng summons, kinasuhan sila, hindi ka mananagot. Okay, Section 7 of Rule 14. What if naman? Another question. Kung preso or prisoner yung defendant, ano yung mangyayari? Kanino iso-serve? Siyempre, alangan naman papasok si sheriff doon sa kulungan, di ba? Or for example, nasa bilibid siya. So, paano siya magso-serve doon? Kasi nakakulong na nga eh. So, kanino iso-serve? Siyempre sa warden. Okay? Sa jail warden or person who manages the jail who shall be deemed as a special sheriff. So, yung sheriff, iso-serve niya sa isang persona na siya ngayon, ang personang ito ay magiging special sheriff. Who can service or when can service be made electronically to a juridical entity? So, for example, paano magagamit yung email? Section 12, when there is refusal on the part of persons mentioned in Section 12 despite 3 attempts on 2 different dates and if allowed by the court. So, pwedeng yung email as a substituted service pag hindi masiserve sa mga persons na to. Okay, yung kanina, yung na-mention natin, yung President, Secretary, Treasurer. So, pag hindi masiserve doon, or imposible, or hindi, after all the best efforts, ask permission from the court to serve it electronically through their email, and that's it. The summons have been served to that juridical. So, summons, let's continue. When does a counsel become a counsel on record or deputized by the court to serve summons on his client? So, syempre, may abogado yan pag nakasuhan niya, pag narinig niya. So, when he makes a special appearance before the court to question the validity of service of summons, among others. So, to question, for example, the validity or the form or the jurisdiction of the court, for example, then he becomes a deputized counsel to receive summons. So, what if the defendant is the Republic of the Philippines? So, syempre, with the Solicitor General. Okay? He is the lawyer for the government. And what if the defendant is an LGU? Then, it may be served upon the executive head or other officers as the law or the court may direct. Well, it could be the legal counsel, chief legal counsel of the LGU, for example. Next, how shall leave of court? So, let's say, dito kanina, with leave of court yung pag-serve ng email, no? Through email or electronic means. Paano ngayon gagawin yung leave of court? First, in writing, and supported by affidavit of plaintiff or some person on his behalf, setting forth the grounds for application. So kanina, for example, electronic, hindi magagawa, hindi masiserve yung summons sa na-mensyong mga tao doon. So therefore, you lay down and support it with the affidavit or with your affidavit for the grounds for the application of summons to be served electronically. So let's continue with the service of summons. Dito naman ngayon, how about if the defendant is unknown? So always remember, pag defendants, if the identity or location of defendant is unknown, publication agad. Because publication, it seems like it will bind, it will like addressing to all. Okay? Publication, public. Because hindi kilala, o hindi alam kung saan, then publicize it through a newspaper of general circulation in a place and time as the court may order. And that must be made with leave of court and within 90 days from the commencement of action. The court shall specify that the defendant should answer within a reasonable time, which shall not be less than 60 calendar days after notice. So tandaan, after filing an action within 90 days, publicize, pag hindi kilala, hindi alam kung saan siya, taga saan siya, sino siya, anong name niya, basta i-describe siya ng court, and it will require na mag-answer siya within 60 days. Okay? Bar 2016, the court-designated administrator argued that the court did not acquire jurisdiction because the following are actions in personam. Action for declaration of nullity of title, personam ito. Action for reconveyance of property or ownership, malalaman natin mamaya deeper kung ano yung mga actions in personam. So therefore, the defendant resides abroad. The defendant, moreover, this resides abroad and is uncertain if he is still alive. So hindi alam kung saan siya sa abroad at hindi alam kung buhay pa siya. So inargue ng administrator na summons by publication is not sufficient. So the court said that the two actions above are in personam. So ito nga yung final action because the judgment is binding upon the parties only. So yan yung isang feature, distinction ng action in personam, meaning it will just oblige the person, one person or some persons, not the whole world. Okay? But bakit publication yung service of summons? Kasi sabi ng court, but this rule on service of by publication if defendant is abroad or is unknown applies to any action, whether in personam, in rem, or quasi in rem. So, going back dito sa service of summons by publication, hindi lang ito sa mga actions in rem. Because usually, ito yung usual na concept. Pag in rem, publication. But in service of summons, this applies to all. Action in personam, action in rem, and quasi in rem. So let's look at the three actions a little bit deeper. So in personam are actions against a specific person or persons. In rem are actions against a specific property. Because ang word na rem ay thing. Okay, rem is thing. Quasi in rem is actions against a person's interest in property. So, quasi kasi ang action na ito ay yung interest ng isang tao sa isang bagay or ilang tao sa ilang bagay. So, that's quasi in rem. What is the purpose of actions in personam? To enforce personal rights and obligations. However, in rem, to determine the status or ownership of a property. And quasi in rem is to adjudicate claims related to a person's property interest. Okay? Hindi ko nababasahin dito, but isa sa mga features is yung effect of judgment. Yung effect ng judgment sa in rem is it binds the whole world, okay, regarding the property. However, in personam, it only binds the parties involved, not the whole world. Dito naman sa quasi in rem, on the parties regarding their property interest. So, mas specific siya. Not just the person, not the persons as a whole, but the interest of that person in that specific thing. That's quasi in rem. Okay? So, yung service of process sa in personam, personal service required. Okay? But again, pag unknown yung defendant or pag hindi alam yung identity, publication. Okay? Ito yung nuance dito. Publication nga sa in rem, but may exception dito. Pag unknown or unlocated yung defendant, then resort to service by publication. Okay? What is equivalent to service of summons? Section 23. So, ano yung gagawin ng defendant na ito ay mag-i-construe as service of summons, and therefore the court will acquire jurisdiction. So, what is that? That is when the defendant voluntarily appears before the court, except to question the jurisdiction or to file a motion to dismiss on the ground of the lack of jurisdiction over the subject matter. Filing for a motion to dismiss other than lack of jurisdiction over the person of the defendant shall be deemed as voluntary appearance. So may isa akong video na yung tanong is this still binding? Kasi meron tayong enumeration, di ba? The 4 grounds of motions to dismiss. Then, this could be filing for an answer. You can file or a motion to dismiss on the ground that the court has no jurisdiction over the person of the defendant. Question in bar 1999. What is the effect of the absence of summons on the judgment rendered in the case? So, paano pag walang summons at may decision yung court? Anong mangyayari sa decision? Then, the judgment is what? It's null and void. Bakit? Kasi, pag walang jurisdiction, pag walang summons, walang jurisdiction, okay, over the person of the defendant. Ano nga uli yung jurisdiction? It is the court's power to hear and decide a case and what? Enforce a judgment. So, pag walang jurisdiction, wala ring judgment na valid. Unless the defendant voluntarily appeared in court, which is deemed equivalent to service of summons. So, let's say nag-file siya ng answer. Let's say nag-file siya ng counterclaim or cross-claim. So, that means that that defendant acknowledges the jurisdiction of the court and he waives the question of jurisdiction. Bar 1999, question, is summons required in the following if an additional defendant is impleaded and defendant who was substituted for the deceased? So, kailangan ba ng summons pag may dinagdagan kang defendant? The answer is yes. Summons must be served on an additional defendant so the court can acquire jurisdiction over his person. Again, this must have due process. So, hindi pwedeng ikaw yung kinasuhan yung kaibigan mo, bigla ka na lang inimplead dyan, bigla ka na lang finailan ng kaso, walang summons sa'yo. So, hindi pwede yan. There must be summons for due process purposes. And then, how about if defendant was substituted for the deceased? No need for summons because it is the court's order ordering him as the legal representative that causes the court to acquire jurisdiction. So, dito naman sa substitution for the deceased, order naman ng court, hindi summons. Okay? Court's order. Okay? For the court to acquire jurisdiction. So, magkaiba. Pag substitution lang, kasi hindi ka naman yung real, yung original party in interest. So, namatay yung original party interest, no need to file summon against you. Hindi ka naman kasi yung original talaga. The only thing needed is order of the court na isa-substitute ka to the defendant. So, let's go now to what happens after the summons have been served. So, this is now what we call as return of summons or service or proof of service of summons. Question, so when should the sheriff complete the service of summons? Within 30 days from the issuance of summons and receipt thereof. So kung ikaw yung sheriff, you have 30 days, 30 calendar days to be exact, no? When and to whom should the sheriff serve a copy of the return? So kanino niya ibabalik or tinatawag ko siyang return kasi report eh. Okay, kanino niya i-report? Within 5 days from the service of summons, the server shall serve the copy of the return to the plaintiff's counsel. So, plaintiff's counsel kasi siya naman yung nagkaso eh. So, para ipaalam na na-serve na sa defendant so that the counsel would also be aware na alam na ng defendant yung kanyang kaso. How? Paano? So, kung ikaw yung counsel or ikaw yung defendant, yung nag-file ng case personally or by registered mail or by electronic means authorized by the rules. So by email, for example. Question: ano yung ilalagay sa summons? Ano yung dapat contents niya? So, first, write in writing by the server, or it can be computerized, electronic, typewritten. Shall set the manner, place, and date of service. Paano ginawa, saan, kailan na-serve yung summons. Specify any papers which have been served with the process. Name of the person who received the same, the summons. If not made by the sheriff or his deputy, shall be sworn to. Okay. If served by electronic mail, a printout of said email with a copy of said summons served and the affidavit of the person mailing. So, pag, for example, ito yung sinerve siya by email, ipiprint pa rin siya. Okay? Ipiprint pa rin siya, and yun yung i-report. Okay? At yung affidavit nito, isa-serve ibabalik. Could be also be given to the court. Okay? Pag ginawa rin ito ng sheriff, then a copy should be given as well to the plaintiff's counsel. How should proof of service be made if service has been made by publication? So, di ba kanina may mga options tayo doon as a substituted service? So, affidavit of the publisher, editor, business, or advertising manager. A copy of the publication shall be attached, and an affidavit showing that a copy of the summons and order for publication has been deposited in the post office sent to the defendant's last known address. So, ito yung dapat tatlong requirements for a valid service of summons by publication. So, yung may-ari o yung manager, publisher ng newspaper, or number 2 is how it looks, kumbaga, sa newspaper na yan. And yung gumawa nito, affidavit niya, okay, na umorder din ng publication through a proof nito. Ang proof nito is yung nag-send siya, nag-deposit siya sa post office ng summons then to the defendant's last known address. So again, kahit nga i-publish mo, isend mo pa rin yung summons sa last known address ng defendant. So double assurance na malalaman talaga niya. Okay. BAR 2016, sorry sa piyok, requirement for a valid substituted service of summons. So again, parang inulit lang, but again, to be valid, there must be indication of serious efforts that service by in person has been made. Service of summons in a personal manner has been made to the defendant. However, this has been made specific by 2019 amendment. There must be at least 3 attempts in 2 different dates. Okay, the impossibility of personal service within 30 days from the issue and receipt of summons by the sheriff, and again, serious efforts as shown by these 3-2. Okay, 3-2. And since it is a substituted service, yung name ng nag-receive. So, it could be a person of legal age and sufficient discretion pag ginawa ito sa residence. Number 2, pag ginawa ito sa office, then the person who is receiving the correspondences customarily sa office na yan. Or, pag hindi ka pinapasok sa subdivision or sa condominium, yung pangalan ng Chief Security Officer or ng officer of the association or homeowners association na tumanggap ng summons. So this is very crucial kasi maraming mga defendants yung kinukuntsaba nila yung security. Wag papasukin yan. Okay? So ito rin yung ginawa ng law. Ayaw nyo so edi sa security na lang, and that is a valid service of summons. And yung may obligasyon ngayon ay yung security na magbigay alam sa defendant na may kaso ka. Okay? So, let's go now sa extraterritorial service, meaning outside our territory. kailan ito i-resort? When should this be resorted to? When the defendant does not reside or cannot be found in the Philippines or is temporarily out. And the action affects the following. Number 1, it affects the personal status of the plaintiff. Okay? Yung marriage niya, yung legitimacy niya. Second, the subject is a property within the Philippines in which the defendant has a claim or interest. Okay? And then number 3, the demand consists of excluding the defendant. And number 4, the property of the defendant has been attached within the Philippines. So dito, personal matters, dito naman ay material or property matters. So may claim siya, i-exclude siya, or i-attach yung property niya. So resort to extraterritorial service pag ganito. So hindi lang basta-basta na defendant lang siya, no? But it affects his personal or material resources. So paano ito ginagawa? How can extraterritorial service be effected? First and foremost, by leave of court. Always ask permission. Yung kanina, publication, ganun rin, no? By leave of court and by personal service under Section 5. Okay? This one, ang apat na to, personal service. Pero meron din tayong other 3 na hindi siya personal service. Pero let's go first sa personal service pag nasa abroad siya. So ano yung gagawin? Pag nasa abroad, ganun pa rin. Yung personal service at parang substituted service pa rin, pero at this time sa abroad na ginagawa or ginawa, no? By sending an email to the defendant's email address if allowed by the court. So ganito rin, no? Gagawin siya sa this one is within pala sa Philippines, no? Dito, substituted service or by under international conventions in which the Philippines is a party. So na-mention natin sa introduction ng video, sa start ng video, kung ano itong mga specific or examples ng international conventions. So again, dito pala sa letter A is by personal service na parang substituted service din. And let's say sa residence niya dito sa Pilipinas, wala siya. So isi-serve mo rin sa legal age and person with sufficient discretion doon sa bahay niya. Letter C, ito naman by common sense at reason, publication din. But at this time, sa place and time that the court may order. And isi-send out pa rin yung summons sa last known address niya. Okay? Or in any manner which the court deems sufficient. So dito naman mga messaging apps, mga chat apps, pwede yan as long as the court deems it sufficient. The order shall specify that the defendant must answer within the reasonable time, which shall not be less than 60 calendar days. So again, pag requirement to answer 2 months, 60 days. Actually hindi 2 months, dapat 60 calendar days yung answer. Okay, calendar ha. Always remember the word calendar days, not business days. The reason is may mga holiday na minsan biglaan. So, makukonfuse yan. Let's now go to answer. But before that, meron tayong verse na very timely. He has told you, O man, what is good and what does the Lord require of you, but to do justice and to love kindness and to walk humbly with your God. Micah 6:8. Bar 20 or bar 2006 question. What should the petitioner do if the defendant fails to answer within the 15-day reglementary period? Answer: the petitioner should file a motion to declare the defendant in default and allow the petitioner to present evidence ex parte. So dito naman sa answer, nag-file ka ng kaso and the court will give the defendant 15 days to file an answer. Pag hindi siya nag-file, then you as the petitioner should file a motion to declare the defendant in default. Meaning, that would give the court a signal to allow you to present evidence ex parte. okay, or without the other party, or at your own initiative. Bar 2006 question: what action of the defendant will make it justifiable for a judge to deny the motion to declare the defendant in default? Ano yung pwede niyang gawin na i-deny yung motion na yon, na i-declare yung na mag-present ng evidence ex parte, yung petitioner? Answer is when the defendant has filed a verified answer to the complaint against him. So, file a verified answer. Again, verification, the three elements that the petition has been made with truthfulness, second, in good faith, and third is with evidentiary support. Let's go to motion. So these are just overview, hindi ito in-depth. We're just looking at these concepts since these are mentioned doon sa ating mother question kanina or sa main question kanina. Okay? So when it comes to motion, we would always hear the word or the phrase omnibus motion rule. So this was asked in bar 2010. So what does it mean? It means that it is when a motion attacks a pleading, order, judgment, or proceeding, it shall include all objections then available, and all objections not included shall be deemed waived. Okay, this is for the interest of speedy disposition of justice. So lahat ng available at that time must be included, otherwise they shall be deemed waived. Okay, there are other terms dito sa labor which nasa dulo na dila ko, but I may not. We can go back sa other videos, okay? And still again, for the interest of speedy disposition of justice, meron na tayong mga pinagbabawal na motions under the 2019 amendments. And I think these ones should be included na sa answer. So these are motion to dismiss, except on the following grounds, yung tatlo na yon na minention natin: res judicata, litis pendentia, and lack of jurisdiction over the subject matter. And again, lack of jurisdiction naman sa person of the defendant, it is subject of our discussion sa first question of our video. So, Remedial Law Review 1, version 1.1. Letter B, motion to hear affirmative defenses. Okay, that's a prohibited motion. Another prohibited motion is MR of the court's action on the affirmative defenses. Number 4, motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. Okay, letter E, motion for extension of time to file pleadings, affidavits, or any other papers, except a motion for extension to file an answer as provided by Section 11, Rule 11. And letter F, motion for postponement. So, motion to file extension of time and postpone are prohibited motions except in these following grounds. So, again, acts of God, force majeure, or physical inability of the witness to appear and testify. So, again, God, nature, and physical inability ng witness to testify. So, I think meron discussion si Justice Singh, which I have remembered. How about if physical inability of the counsel? So, according to her, hindi naman unbending yung rules. Okay? As long as there is justifiable grounds, reasonable grounds, then the law or the procedure should not be strewed strictly against substantive justice. Okay? If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must still be terminated on the dates previously agreed upon. Okay, that could be during the pre-trial. Okay, the agreement as to the time. Now, speaking of speedy justice and other significant changes, let's go now. Ano ba yung mga significant changes sa 2019 amendments? So, ano yung mga significant changes sa 2019 that were enacted for the speedy disposition of justice? So, some of them are main. So, the main goal is to improve the flow of court proceedings and avoiding delays. Now, complaints must now include evidentiary matters, such as judicial affidavits and copies of documents. So, you cannot file a complaint without evidentiary support. Number 2, now there are prohibited motions which are considered non-litigious. Litigious motions may be heard at the judge's discretion. So kanina, yung mga motions na yun are non-litigious. But, again, as what you have just read, pag litigious yan, it's upon the court's discretion kung may hearing for that. Number 3, hearing of motions is now deleted. Number 4, Rule 16 on motion to dismiss is now deleted and some provisions are integrated in other rules. Number 5, new provisions on service and filing through accredited courier and email. Provisions on extraterritorial service has been amended to include modes of service as provided for international conventions to which Philippines is a party. For example, the Hague Service Convention. So, hindi pala yung kanina I mentioned na before the video, but now it's during this video. So, if you're still here, then ito yung bago. Yung sa extraterritorial service, we can now resort to international conventions. So, kung sa documentary evidence, meron tayong apostille, okay? Sa service of summons, meron naman tayong the Hague Service Convention. Number 6, requires judges to be more engaged. Well, this could mean that less passive but more active role in the disposition of cases. Number 7, pre-trial now needs to be concluded before the case is referred to the court-annexed mediation or CAM. But only if, number 1, there is a genuine issue involved. So, dapat ma-terminate o ma-conclude na yung pre-trial pag may issue talaga. Okay? And then if the answer tenders an issue, or if the answer does not admit the material allegations in the adverse party's pleadings. So, ang opposite nito, pag walang issue, then walang requirement to conclude the pre-trial before referral to the court-annexed mediation. It can be that i-refer lang siya sa court-annexed mediation para ma-settle na at amicably settle na yung case. Number 8, if the CAM fails, then we have the JDR, which may be availed only if the judge of the court or the regional court is convinced that settlement is still possible. So, this would infer na yung previous, before the 2019 amendment, the CAM requires referral to the JDR or Judicial Dispute Resolution. But at this time, yung CAM, diretso na sa trial pag yung court convinced na hindi na talaga ma-amicably settled. So, this would lead to the speedy disposition of cases. Okay? Number 9, initial presentation of evidence needs to take place not later than 30 calendar days after termination of pre-trial. So, this is a new provision. So, after na-terminate, again, 30 calendar days after termination of pre-trial, the party must, or the petitioner generally must present its evidence. Number 10, continuous trial of cases is now adopted. Plaintiff has 90 calendar days to present evidence, or 3 months. And this would require as well the one witness rule, the best witness rule. Okay? And then, defendant has 90 calendar days to present evidence. So, 90, that's 6 months. Total of 180 calendar days, or 6 months. But may be extended to 300 days if there is third, fourth, etc. party claim, counterclaim, or cross-claim. So, 180 or 300. So, that is the rule on continuous trial. And then, after submission of the case for resolution, judgment must be rendered within 90 calendar days with or without memoranda. So, we have a total of what? 6 months. Let's say walang other party claims. So, 6 months plus 3 months, then we have 9 months all in all. Maximum for a trial to be done. So, we have a total of at least, again, 9 months maximum. Okay? But it can be less, especially if mabilis, if less ang dockets ng court. Okay? Number 11, submission of the case motu proprio for judgment on the pleadings or summary judgment. No issue if there is no genuine issue, or if the answer fails to tender an issue, then motu proprio, the court can proceed for decision on judgment on the pleadings or summary judgment. May pagkakaiba tong dalawa ha. Please remember. And then if the answer admits of the material allegations. So again, pag walang issue or inadmit yung allegation, inamin. So again, submit it for summary judgment or judgment on the pleadings. So if I can remember, judgment on the pleadings, from the word itself, yun lang, doon na talaga magbe-base yung court. Pag summary judgment, then that could include hearing or like a quick or summary trial. Okay. Number 12, not subject to appeal, certiorari, prohibition, or mandamus are actions. Number 1, actions of the court on the motion for summary judgment. Okay. And then because it's summary. Number 2, action of the court on the motion for judgment on the pleadings. Okay, these two are kumbaga speedy disposition. And then order denying the demurrer to evidence. Again, order denying the demurrer to evidence would equate, so diba demurrer to evidence, if granted, then it's acquittal. Okay, then if it's denied, then that means that there is conviction. So if I got it correct, no, denying the demurrer to evidence. So pag demurrer to evidence is the evidence is insufficient to convict. So if deny, then i-deny syempre yung wala siyang conviction. So it's not subject to appeal. So acquitted siya, no? Not subject to appeal, certiorari, prohibition, or mandamus. Rules on contempt. Kasi kanina doon sa Writ of Kalikasan, subject to contempt yung mga defendant, for example, defendant corporation na may alleged environmental violations, they will be subject to contempt if they will not comply with the order. So, let's first go to direct contempt. How is it committed? A direct contempt is when a person behaves or misbehaves in the presence of the court or so near the court as to obstruct or interrupt the proceedings before the same. So, binastos yung court proceedings or inistorbo yung court proceedings. Ito yung essence ng contempt. So, never misbehave or disrupt the proceedings in court dahil pwede kang makulong through direct contempt. So, this again, the keyword here is in the presence or so near a court. So, because that's direct, right? Direkta. Umaga sa harap mismo ng judge, sa loob mismo ng korte, or malapit mismo sa korte na inabot yung sigaw mo sa loob na natigil yung hearing dahil sa iyo. So it includes disrespect towards the court, towards the judge, offensive personality towards, let's say, the defendant, sinuntok mo, or sa mga teleserye, sa drama. Okay, may ginawa ka dyang iskandalo, refusal to be sworn as a witness, refusal to answer as a witness, dahil witness ka nga no? So, direct contempt yan. And refusal to sign when lawfully required. Okay, how about yung sinabi mo, hindi ko po alam. Hindi ko po alam, Your Honor. Hindi ko na po maalala, Your Honor. Well, can that be construed as refusal to answer? Okay. These are all defendants' refusal of the commands of the court. So that's another way of saying it. Direct contempt is disobeying the commands of the court. Bar 2012 question and Lipa versus Tutaan. So, importante yung definition ng direct contempt as to disobedience of the party to the commands of the court, because tinanong ito nung Bar 2012. If a party who loses in an ejectment case refuses to leave the condo unit despite the writ of execution, can he be cited in contempt? So, mayroong writ of execution. Ayaw ng party umalis. So, pwede ba siyang ma-cite in contempt? The answer is no. Bakit? Kasi meron bang disobedience of the court dito? writ of execution, tandaan natin, is not a command of the court to the party. But writ of execution is directed to the sheriff and not to the losing party. So, medyo somehow for me, this is tricky, but this is the suggested answer. Yung losing party, hindi siya yung subject ng writ of execution. Again, it is commanding the sheriff, na yung sheriff, paalisin mo yon yung tao doon, yung nag-possess sa kondo na yon. That's what the writ is. So, pag nag-disobey yung party, it's not a refusal. Refusal to let the sheriff enter is not the refusal of the court's orders under Rule 71. Okay? Because again, ang inuutusan sa writ of execution ay yung sheriff. Ano yung remedy? The remedy is for sheriff to oust the defendant with the assistance of the police under Rule 39, Section 10 of the Rules of Court. So, hindi i-cite in contempt. Okay? Kasi wala siyang disobey na direct in the presence of the court or even in indirect contempt in that case. But what the procedure or what the remedy is, forcible talaga, no? Tumawag talaga ng police. Okay? Kumbaga may drama talaga. That's Rule 39. What is the method and penalty for direct contempt? Method is summarily. Penalty is if before the RTC or similar court or higher court, the penalty is not exceeding 2,000 or imprisonment of not exceeding 10 days or both. So maximum 10 days pag direct contempt. Makukulong talaga at least or maximum of 10 days. Or pag lower court, we have maximum of 1 day or not exceeding 200 pesos. So 1 day na kulong. Okay? Dahil indirect contempt. So malalaman natin ngayon ano yung indirect contempt. The keyword here is of course yung opposite kanina, not in the presence of the court. But to be more specific, this is misbehavior of an officer in the performance of his official duty. Okay? For example, kanina yung sheriff, pag hindi niya yun in-execute, yung writ of execution, then he can be cited in indirect contempt. Makukulong siya 1 day at least, or maximum. Number 2, disobedience to a lawful writ, process, order, or judgment of a court. Disobedience naman ito, of course, considering na hindi siya within the presence of a court. Includes re-entering a property after ejectment or disturbing the possession given to the person adjudged to be entitled thereto. And then number 3, abuse or unlawful interference with the processes of a court not constituting direct contempt. Maybe you have done it beyond or far from the court or in your home but na-disturb mo pa rin yung court proceedings. Number 4, any improper conduct tending to obstruct the administration of justice. So parang catch-all phrase ito. Na pag may obstruction of justice, you can be cited in indirect contempt, makukulong ka, maximum of 1 day, magpe-penalty ka, maximum of 200 pesos or both. Number 5, assuming to be an attorney or officer of the court without authority. Again, pag nag-assume ka lang dyan, indirect contempt. Failure to obey a subpoena duly served. Subpoena duces tecum or subpoena ad testificandum. So, ayaw mong ibigay yung mga document, makukulong ka 1 day. Ayaw ka mag-testify, pinasubpoena ka, makukulong ka 1 day. Number 7, the rescue or attempted rescue of a person or property duly held by an officer. So, naghiro-hiroan ka, makukulong ka. Nirescue mo siya sa mga police, no? Bar 1996, failure of a lawyer to notify the court that his client has died is subject to indirect contempt because again, a lawyer is an officer of the court. So, indirect contempt pag lawyer ka, may mga hindi ka ginawa na dapat mong gawin or may mga misbehavior ka, then you can be subject to indirect contempt as long as these are obstructing the procedures or the administration of justice. So let's have a quick comparison and distinctions between direct contempt and indirect contempt. Alright, So, definition of direct contempt: in the presence or near the court. Indirect contempt: outside the presence of the court. So, let's highlight the word outside. Okay? So, in the presence and outside the presence. Governing rule, Section 1 and Section 3 of Rule 71. Examples: insulting the judge, refusal to answer as a witness. So, nasa courtroom talaga to, no? Indirect contempt is na bigay na yung order, ayaw mo pa rin. Subpoena, ayaw mo pa rin. Filing false pleadings. Well, that could be misconduct by a lawyer. Okay? Procedure, summary, proceedings sa direct contempt. The court may act immediately and punish the contemptor. Yan palang tawag, no, sa nag-commit ng direct contempt, contemptor. So, summary lang, immediately. While sa indirect contempt, requires filing of a written charge or motion, and the contemptor is entitled to a hearing. Kasi outside the court nga siya eh. So, it would require a hearing. Ito naman, within the court na, so it should be decided on the spot, okay, or immediately. Okay. So, yun na. Just read the rest. Bar 2019, what are the methods of initiating and hearing indirect contempt charges? So, ano yung mga methods? Number 1, by the court, may be initiated motu proprio by an order or other formal charge of the court requiring the respondent to show cause why he should not be punished with indirect contempt. So, by order of the court or formal charge of the court. And another distinction of this is it can be filed by the petitioner through a verified petition with the supporting particulars and certified copies of documents or papers involved. So, syempre, dahil nangyari to outside the court, then it would need substantiation. And it could be that the petitioner is the one that has observed the misbehavior or misconduct or the conduct that constitutes indirect contempt. Then it would require verified petition. Again, veritas, it would require the oath of truthfulness because ayaw naman natin ng mga puro na lang kasinungalingan, puro na lang lies na petition. Oy, nag-indirect contempt, nag-commit siya ng acts constituting indirect contempt. So, mangyayari niyan, pag hindi siya verified, then mangyayari niyan, puro na lang tayo, manipulation, lies, harassment. No? So, if ikaw naman yung nagpetition na false naman, so you can still be subject by indirect contempt, right? So, hearing, generally, it shall be heard and decided separately unless the court orders the consolidation of the contempt charge with the principal action for joint hearing and decision upon its discretion. So, pag may kaso na principal at may allegedly may indirect contempt, ang general rule is it shall be heard and decided separately. Kasi nga, parang, if you look at it, merong principal case, and then parang ito, parang another animal naman siya, no? And therefore, it should be heard separately unless yung court mismo nag-order na i-consolidate yung dalawa. So, this was asked in the bar 2019. It is sufficient for a court to issue a show cause order requiring the defendant to answer within 10 days and conduct a hearing with notice to the parties in order to initiate contempt proceedings. The motion to quash should be granted because the court did not order the consolidation of the principal action and contempt charge before it initiated the indirect contempt proceeding. So this is my own personal answer sa bar 2019 question. Kasi by default, it should be answered or it should be heard separately. But at this time, the question is, yung question is parang the court has automatically consolidated it to the principal case. And I think the defendant filed a motion to quash that the hearing for indirect contempt should be dismissed. So the answer is, of course, it should be granted because by default, the court should hear it separately unless it gave a prior order that it should be consolidated to the principal action or the principal proceeding. Bar 2012 question. A party filed a motion to declare the defendant in contempt. As a judge, rule on the motion. The motion should be denied. Bakit? Ano yung parang simplehan lang ako sa tanong, but bakit kaya? Because a party filed a motion. Ano nga uli? Yung initiatory, how should the contempt proceedings be initiated? Yun na lang. Diba? Recalling kanina, by the act or order of the judge or the court motu proprio, or filing a what? A verified petition. So, hindi pwede yung motion, because again, what is a motion? It is what? An application for relief other than a pleading. It is different from a verified petition, which we will compare in a while. Okay? A charge for indirect contempt is initiated by a party's verified petition or by court's order motu proprio, not a motion. Rule 71, Section 4. Okay, so that's the answer. So, let's compare or distinguish the two. Okay, motion is a written or oral application to the court for an order. So, motion is you're asking an order. However, a petition is a formal written request. So, dito yung distinction. Petition, written talaga yan. Motion, either written or oral. The purpose is for the court to issue an order or ruling on a specific matter within an ongoing case. Tandaan natin pag motion, may ongoing case and you are just asking for an order. While petition, wala pang case. You would like to initiate a case. Okay? To start, okay, to take judicial action. So, magkaiba rin yung governing rules nila. Verification requirement, syempre from the word itself, verified petition, it requires verification with those three elements. And motion, generally not required. So, basahin nyo na lang yung the rest. Okay? So, a statement made under oath or affirmation, ito yung meaning ng verification again, is a statement. Verification is a statement made under oath or affirmation by the petitioner in which they declare the facts that stated in the petition are true and correct or accurate to the best of their knowledge and belief. So, verification again is a statement na totoo ka, hindi ka nagsisinungaling dahil nakakapagod ang pagsisinungaling or ang mga sinungaling. Okay? Verification, napaka-importante yan. Okay? So, ang tanong, where should charges of indirect contempt be filed? Ang tanong, bakit wala sa direct contempt? Kasi nasa court na siya di ba? Doon na siya nangyari. So, doon na rin siya kumbaga, i-hearing. Pero, sa indirect contempt, pag yung order ay in-issue ng RTC or against RTC or a court of equivalent or higher rank, so let's say CA, CTA, or Supreme Court, then before such court. Okay? So, pwede rin na yung officer na in-appoint, let's say yung judge, yung sheriff, hindi sinunod or may indirect contempt, then before such court pa rin. However, magkaiba siya sa committed sa MTC or lower or first level court, because it can be filed with the RTC of the place in which the lower court is sitting. So, sa appellate court siya i-file. Or with such lower court, subject to appeal to the RTC. So, pwede rin naman with the MTC, yung pag-file ka ng indirect contempt. Pero practical purposes, I would think, na-file mo na lang siya diretso sa RTC kasi pag may appeal pa yan, then it would take, another set of processing. Ano yung punishment if a judge guilty with indirect contempt? So, magkaiba, i-divide siya sa against RTC or against a lower court. Delete natin to. So, pag committed against RTC, not exceeding 6 years. Okay? Not exceeding 6 years or 30,000 or both. Not exceeding 1 month pag against lower court or imprisonment until obeyed. So, iba yung 1 year kanina. Yung 1 year kanina is nasa direct contempt yun. Pero pag indirect contempt, medyo mas malaki, no? Mas malaki sa indirect contempt against the lower court. Kasi 1 month. Not exceeding 1 month. Doon kanina, not exceeding 1 day. 5,000 or both. Or imprisonment until obeyed. So, may pwedeng until obeyed pero hindi siya exceeding 1 month. Okay. Sa committed against RTC, not exceeding 6 years, o pwede ring imprisonment until obeyed pero wag dapat mag-exceed or aapaw sa 6 years. Okay, 6 years or 1 month. If order is a violation of a writ of injunction, TRO, or status quo order, he may be ordered to make a complete restitution or with the amount proved, or court may issue writ of execution. So ito naman yung writ of injunction, okay, to stop, to prohibit an act, temporary restraint order. So ang order, it could be not imprisonment or not payment of fine, but to restitute or to return what was lost, or i-execute or i-attach yung property mo to satisfy the order that you have violated. Bar 2019 question: what is the proper mode of appeal should a person decide to assail his contempt citation? So, ano yung remedy? Kasi, sinight ka na in contempt. Meron bang remedy available under the law? So, since wala, then file a petition for remedy or prohibition under Rule 65. So, follow me for another video which we will discuss Rule 65 deeper, or certiorari. Okay, that's a special civil action for certiorari. Bar 2019 question: what shall be done to execute or to the execution of the judgment pending appeal of the contempt citation? So let's say may order na, may writ of execution na, in appeal sa higher court under Rule 65, so syempre, it shall be suspended. Resolution. It shall be suspended pending resolution for such petition for certiorari. Number 2, provided that such person shall file a bond. So pag mag-appeal ka, you should file a bond so that the bond will be used if the judgment should be decided against him or against such person who filed the bond. Okay. This is to avoid a malicious filing of appeal. So again, suspended writ of execution, filing of a bond, and conditioned upon the performance of the judgment should the appeal be decided against him. So syempre, pag in favor of you yung appeal, yung judgment upon appeal, if favorable sa nag-file ng bond, syempre ibabalik yung bond. But if against, then the bond shall be released against the person who filed the bond. Section 2. Thank you very much for watching. God bless you. Bye-bye.